The Supreme Court of the United States just signaled that the era of assault weapon bans is coming to an end. After years of watching from the sidelines as lower courts openly defied their precedents, the justices have finally stepped in. This isn't just another legal update. It is the beginning of a constitutional earthquake that could dismantle every AR-15 and semi-automatic rifle ban in the country overnight. If you live in California, Illinois, New York, or any of the 10 states currently criminalizing the most popular rifle in America, you need to pay close attention. On November 8th, the Supreme Court granted certiorari to Snope versus Brown, consolidating it with challenges from Maryland and Illinois that have been sitting in the petition pile for over 18 months. This wasn't a random selection. The court deliberately chose cases that present the cleanest constitutional questions with the starkest circuit splits.
And what happens next will redefine the Second Amendment for the next century.
Subscribe right now and hit the notification bell because the mainstream media is largely ignoring the specific legal maneuvers happening in Washington, D.C. right now. And these maneuvers are the key to your right to keep and bear arms. Right now, we are witnessing a national crisis of banned firearms. As we sit here today, over 100 million Americans, nearly a third of the population, live in constitution-free zones where owning a standard semi-automatic rifle can land you in a federal penitentiary for a decade. We aren't talking about weapons of war or obscure military hardware. We are talking about the AR-15 platform, a rifle so common that there are now more of them in civilian hands than there are Ford F-150s on American roads. There are over 24 million of these rifles in circulation, making them the #1 selling rifle in America and legal in 41 out of 50 states.
Yet, states like Maryland, Hawaii, and New Jersey have enacted bans that prohibit over 200 specific models by name. Maryland's Firearm Safety Act banned 45 specific rifle models and prohibited any copycat weapons that share their operating characteristics. In California, that number exceeds 300 when you factor in every variant. Illinois enacted the Protect Illinois Communities Act after the Highland Park shooting, criminalizing semi-automatic rifles with detachable magazines in any one of several additional features. These states haven't just regulated firearms. They have attempted to erase an entire category of technology from the hands of law-abiding citizens. How did we get here? For years, the Supreme Court issued landmark rulings like Hella and Bruin, establishing that the government cannot ban arms that are in common use for lawful purposes. But instead of following the law, lower circuit courts have engaged in what Justice Clarence Thomas has called Bruin evasion. Federal judges in the 4th, 7th, and 9th circuits have essentially gone rogue, inventing tests found nowhere in the Constitution to justify keeping these bans in place. After the Supreme Court decided Heller in 2008, establishing that the Second Amendment protects an individual right to bear arms, lower courts faced a problem. How do you uphold popular gun control laws when the Constitution says the right shall not be infringed? They got creative. Federal appellate courts invented the two-step approach that the Supreme Court never authorized. Step 1 asked whether the regulated weapon falls within the scope of Second Amendment protection. Step 2 applied intermediate scrutiny, balancing government interests against individual rights. This framework allowed judges to acknowledge Second Amendment rights exist while upholding virtually any restriction they personally favored. The Fourth Circuit pioneered what they called the military features test. If a firearm shares characteristics with military weapons, courts can exclude it from constitutional protection based on its design rather than its common use. In the recent Snoke versus Brown case, they went so far as to argue that AR-15s are military-style weapons designed for sustained combat, completely ignoring the fact that they are used millions of times a year for hunting, sport shooting, and most importantly, home defense. The Seventh Circuit went further, ruling in Firearm versus Highland Park that because AR-15s are more dangerous than other weapons, states can ban them even if they're commonly owned. Read that logic carefully. The more popular a firearm becomes, the more dangerous courts declare it, which somehow justifies banning it despite its popularity. It's constitutional reasoning that eats itself. Courts cited 19th century laws against Bowie knives to justify banning modern rifles, even though those laws regulated how people carried weapons in public, not whether citizens could own entire categories of arms. The Ninth Circuit even upheld California's ban by citing medieval English laws restricting crossbows among the peasantry. A 14th century law disarming English commoners became the justification for disarming 21st century American citizens. This was the breaking point. The Supreme Court watched this judicial rebellion for 3 years and saw the absurdity reach a level that the highest court in the land could no longer ignore. Then Bruin happened in 2022, and the Supreme Court demolished the entire framework. Justice Thomas wrote that if the Second Amendment's plain text covers the conduct at issue, the Constitution presumptively protects that conduct, and the government must demonstrate that its regulation is consistent with the nation's historical tradition of firearm regulation. No more interest balancing, no more intermediate scrutiny, text, history, and tradition only. Lower courts should have struck down assault weapon bans immediately. But here's what they did instead that forced the Supreme Court's hand. After Bruin came down, gun rights advocates expected lower courts to invalidate laws that couldn't satisfy the historical tradition test. Instead, federal judges engaged in what can only be described as constitutional resistance. The Fourth Circuit reheard case post-Bruin and issued a decision that openly admitted the Supreme Court's methodology was unworkable and shouldn't apply to assault weapon bans. That's a federal judge announcing that Supreme Court precedent is inconvenient. So, he's ignoring it. Illinois district courts acknowledge that AR-15s meet Heeler's common use standard with 24 million in circulation, then ruled they could be banned anyway based on their potential for misuse. The reasoning collapses immediately under scrutiny. Potential for misuse would justify banning automobiles, which kill 40,000 Americans annually, or alcohol, which contributes to 95,000 deaths yearly. 23 federal judges have now issued decisions post-Bruin, upholding assault weapon bans using reasoning that directly contradicts the Supreme Court's command. That's not a few rogue judges misunderstanding precedent. It's systematic defiance of constitutional authority. 9 circuits have now weighed in on assault weapon bans, with 6 upholding them and 3 striking them down. That circuit split made Supreme Court intervention inevitable. But timing matters, and the court's decision to grant cert now, rather than waiting another term, signals something critical. The conservative majority isn't just annoyed with lower court defiance anymore. They're ready to reassert constitutional authority with a ruling that will bind every state and federal court in the nation. The Supreme Court didn't just pick one case randomly. Justice Brett Kavanaugh, joined by the court's conservative majority, has essentially laid out the roadmap. They are waiting for the perfect vehicle, a case that doesn't just challenge a small part of a law, but goes straight for the jugular of the entire assault weapon narrative. The court is no longer just looking for a reason to avoid the fight. They are looking for the right moment to deliver a clean ruling, one that doesn't just strike down one law in one state, but sets a national standard that prevents any state from ever banning a semi-automatic firearm based on its cosmetic features again. But what would the day after such a ruling look like? And more importantly, what does the data actually say about these rifles that could destroy the government's entire case? While the media screams about weapons of war, the actual data the Supreme Court is currently reviewing tells a completely different story. The entire justification for assault weapon bans rests on a simple claim. These rifles are uniquely dangerous weapons of war, responsible for mass casualty events, and banning them will save lives. That claim doesn't survive contact with actual data. The FBI's Uniform Crime Reporting data for 2022 shows that rifles of all types, including AR-15s, hunting rifles, and every other rifle category combined, were used in 456 murders.
Handguns were used in 8,029 murders that same year. That's 17 times more handgun murders than rifle murders. Knives were used to kill 1,630 people, more than 3 times the rifle total. Blunt objects like hammers killed 521 people.
Human hands and feet killed 749 people, 64% more than all rifles combined. If assault weapons are the uniquely dangerous threat that justifies banning them, why do they account for a tiny fraction of murders compared to weapons nobody's proposing to prohibit? The FBI's active shooter statistics from 2000 through 2023 show that handguns were used in 62% of incidents, while rifles of any type appeared in only 31%. States with assault weapon bans don't show reduced murder rates compared to states without them. California has maintained comprehensive bans since 1989 and experienced higher mass shooting casualty rates from 2019 to 2023 than Texas, which has no such restrictions. The correlation between assault weapon bans and public safety is non-existent. The narrative that these rifles are the primary drivers of violence is an empirical lie. The Supreme Court's Bruin decision requires laws to be consistent with history and tradition, not fear and theater. When the justices look at these statistics, the government's compelling interest argument begins to evaporate. The data creates an impossible problem for states defending assault weapon bans. They must convince the Supreme Court that weapons used defensively, tens of thousands of times annually, are too dangerous for citizens to own, while explaining why rifles responsible for 456 deaths annually justify prohibition, while handguns responsible for 8,029 deaths remain legal. But there's something buried in the current litigation that could end this debate permanently. The petitioner's brief in Snope v. Brown makes an argument that goes far beyond whether AR-15s are commonly owned. They're asking the Supreme Court to establish that firearms suitable for militia use receive the strongest constitutional protection, not the weakest. This flips the entire framework that lower courts use to justify bans. Historically, anti-gun advocates argued that if a weapon has a pistol grip, a collapsible stock, or a threaded barrel, it is too military for civilian use. But in recent filings, legal scholars are pointing back to a Supreme Court case from 1939, United States versus Miller. In Miller, the court actually held that for a weapon to be protected, it must have some reasonable relationship to the preservation or efficiency of a well-regulated militia. In other words, the Second Amendment's protection is at its strongest for weapons that have military utility, not its weakest. The brief documents that private citizens at the founding owned military-grade weapons as a matter of course. The Pennsylvania long rifle was the most advanced military firearm of its era, and civilians owned them freely. Private citizens owned the same muskets used by Continental Army soldiers. Cannons and artillery pieces were privately owned. The Militia Acts of 1792 required able-bodied men to own military weapons and ammunition. Congress didn't just permit civilian ownership of military arms, they mandated it. By labeling the AR-15 a weapon of war, states like Illinois and Maryland have inadvertently walked into a constitutional trap. If they admit the AR-15 is a military-grade weapon, they are essentially admitting it is exactly the kind of arm the Second Amendment was designed to protect. If they claim it isn't a military weapon, their entire dangerous and unusual argument for banning it collapses. It's a checkmate moment that the Supreme Court is reportedly eager to address. This argument puts state attorneys general in an impossible bind. If they admit AR-15s aren't actually military weapons, they lose the dangerousness argument that justifies banning them. If they admit AR-15s are military suitable, then they're precisely what the Second Amendment protects. The respondent briefs try to escape this trap by claiming AR-15s are military style but not military suitable, a distinction without a difference that contradicts itself. When 82% of the country treats a product as a standard lawful tool, that tool is by definition in common use. By banning them, the remaining 9 states are not regulating firearms. They are acting as outliers that are violating the national standard. Justice Kavanaugh noted in a recent statement that it is analytically difficult to distinguish a semi-automatic rifle from the semi-automatic handguns the court already protected in HELA. Here's the nuclear option buried in the current litigation that most people are missing. For years, anti-gun states have argued that while a rifle might be protected, the magazine is just an accessory that can be restricted to 10 rounds or fewer. In 2026, cases like Duncan vs. in California and challenges in Rhode Island have reached a fever pitch. The Supreme Court is now considering an argument that will end this debate once and for all. An arm is useless without its feeding device. If the court rules that the Second Amendment protects arms in their standard factory-issued configuration, then every magazine ban in America from Washington to New Jersey evaporates overnight. This is the domino effect. If the AR-15 is protected, then the standard 30-round magazine it was designed to use is protected. If the Glock 17 is protected, then the 17-round magazine it comes with is protected. This would effectively restore the rights of 100 million Americans to own modern self-defense equipment without fear of a felony charge for a piece of plastic and a spring. If the Supreme Court strikes down assault weapon bans as unconstitutional, the immediate legal consequences will be extraordinary. Every state ban becomes unenforceable overnight. California, New York, New Jersey, Maryland, Illinois, Connecticut, Massachusetts, Hawaii, Delaware, and Washington cannot enforce laws that the Supreme Court declares unconstitutional. The laws become legal nullities. Millions of Americans in banned states regain the constitutional right to purchase and possess semi-automatic rifles that have been prohibited for decades. Gun stores in these states will immediately begin stocking AR-15s and other previously banned firearms. The economic impact will measure in billions as manufacturers redirect inventory to newly opened markets representing over 100 million potential customers. What about the people currently in prison or facing charges for possessing a banned rifle? A Supreme Court ruling of this magnitude creates a massive legal wave of appeals and potential pardons, as you cannot be held for a crime that the Constitution says isn't a crime. This isn't just a win for gun owners. It is a restoration of constitutional governance. Don't be fooled. The anti-gun states are already preparing their post-decision strategy, just as we saw after Bruin, when states responded by declaring every square inch of their territory a sensitive place. We expect states to try and implement massive taxes, liability insurance requirements, or impossible-to-pass training mandates. But the 2026 Supreme Court is different. They have seen the Bruin evasion tactics, and the upcoming ruling is expected to include anti-evasion language so clear that even the most activist lower court judge won't be able to interpret their way around it. Oral arguments are scheduled for April. That's when we'll see how the justices are thinking about these questions. Listen for how they handle the military weapons argument. Watch whether they accept the common use standard as dispositive. The government's brief is due in February when the decision drops, probably in late June. The legal landscape of gun rights in America will transform overnight. We are standing on the precipice of the largest expansion of Second Amendment rights in American history. The assault weapon ban, a term made up by politicians, not engineers, is facing its final days in court. This is why you need to stay tuned. Subscribe now to stay ahead of the curve. I'll be breaking down the oral arguments as they happen and providing a deep dive into the final opinion the moment it drops. Your rights are being debated in Washington right now. Don't be the last to know what the verdict is.